another Facebook Live. My name's Danielle and I'm a Senior Associate at Bailiwick Legal. Just before we launch into today's topic, I just wanted to confirm that the information that is provided is a summary and overview only. It's not constituting legal advice, and you should seek your own legal or other professional advice before acting or relying on anything that is discussed today. So today's topic is credit reports or credit history. So what personal information is allowed on your credit history report, and how long does it actually stay there? So a credit report contains information about any past or current loans or debts and your repayment history. It can also contain other public information such as court proceedings and whether you've been bankrupt or personally insolvent. Your credit report is an important measure of your financial reliability or stability, and it is reviewed by banks and other financial institutions as well as other consumers, particularly when applying for credit cards, loans, or buying a house. So credit related information is actually regulated by the Privacy Act, and it's also regulated by the Privacy Regulations and the Privacy Credit Reporting Code. So this legislation covers what is allowed to be on reports about credit, the deletion of information, access to credit information, and the accuracy and security of the information that is held. Last year in February, the Federal Parliament did pass the National Consumer Credit Protection Amendment, Mandatory Credit Reporting and Other Measures Bill 2019, which does set out some legislative changes around credit reporting. The changes commenced on the 1st of July 21 and are aimed at ensuring that credit reporting bodies or agencies have a more complete and comprehensive picture of a consumer's creditworthiness, and this is done by mandating that certain credit providers supply information about positive credit matters, such as how well a person is meeting their repayment obligations, as opposed to the focus being on the negative credit matters. So under the Privacy Act, there's a number of different types of information that can be recorded on your credit report, and this includes consumer credit liability accounts, monthly repayment history on credit accounts such as credit cards, mortgages, any overdue accounts such as defaults and serious infringements, bankruptcy, debt arrangements, personal insolvency, and also court proceedings. So your personal information is retained only for a certain period of time, and this will differ depending on what that information is. So for example, with court proceedings, information is typically only retained for a period of 5 years from the day on which the judgment is entered to which that court proceeding relates. However, credit reporting information relating to repayment histories is typically only retained for 2 years, starting on the day on which the monthly payment to which the information relates is payable. So generally, information can only be removed from your credit report once the relevant retention period has passed. So in the example of court proceedings, 5 years, and in the example of the repayment history, 2 years. However, it is possible to request early removals or amendments to your credit report to reflect satisfied debts so that they don't show as outstanding. There are a number of credit reporting agencies that can provide you with an updated copy of your credit report on request, or assist if you have any further information. Otherwise, we have provided clients with assistance, either just with gaining access to a copy of their credit report, or also in terms of removing and amending entries that are no longer relevant or have been satisfied. So if you have any questions about your own credit information or credit history report, or want to go down the path of looking at removing or amending some older entries, please don't hesitate to reach out. I hope you have a good afternoon and a lovely long weekend, and I will see you next month for my other Facebook Lives.